Okay, so last class we discussed about trade secret protection. Okay, so you have learned the another form of IP, whatever you are calling that trade secret. Trade secret. Okay, so you have now idea about trade secret. You have now idea about patent, and say you have to take a decision whether you will go for patent, whether you will go for trade secret, the pros and cons of each forms of IP, and what are the area where you can consider in the patent and trade secret there is an overlap, and for individual purpose which is the better protection mechanism, and for societal purpose what will be the better protection mechanism, and where the risk for individual also where the risk is minimum, where is the risk is maximum, and also where is the profit is maximum, and where is the risk is minimum. So, how can you make a decision out of that? So, today I will discuss about that aspects where the patent versus trade secret, and a business entity will make a decision or an individual trying to create an entrepreneur, how he will decide which will be give him better protection considering different aspects. Okay. So, you may not get this any specific book, you will get it from different literatures, and you yourself can lot of research paper you may get it, and we are not discussing the theoretical aspects, we are discussing the practical aspects. So, let us see how we can go forward. So, patent protect what? Patent protect invention. And what is invention? Invention is product or process. Okay. Now, come to trade secret. Okay. Trade secret protect what? Information. Okay. And what are the attributes of the information? You know that. What are the attributes of information? Information having commercial value, okay, and information will give a competitive edge, that you also know, competitive edge, and information is you are keeping information secret, also sufficient step you are taking to keep the information secret. Okay. So, now whether you can link this information with product or process, okay, whether the attributes of the product can be an information or attribute of the process can be an information, and you know what is the ambit of information. I already told you, it is information having that is a product, process, compositions, or any composition, and say process of making something, okay, client list, all the things can be an information. So, definitely the attributes of the product or process is information, and information and product and process, definitely you are telling the patent may have commercial value, may give competitive edge, and you may keep secret. So, you are telling that there is a possibility that product or process can come in the form of information and can come in the form of trade secret. Okay. So, now let us say you have created a product or process, let us say process, just like the last class we are discussing that a Coca-Cola. Let us discuss of that. Let us say Coke, some Coke, let us say a cold drinks formulation, cold drinks formulation, formulation which will give formulation. Formulation means, as you are engineer and technologist, what do you mean by formulations? Formulations means just like say you may consider a particular composition or particular formula or particular say addition of two components that is with particular ratio that is giving a particular taste or giving particular attributes to the product. So, now like this part you can, whether this is formulation I can consider within the purview of product, or we may consider the process of that can be also come within the purview of invention. Okay. Now, formulation is also there is a composition. I told you composition is also formulation, or say process parameters can be also considered information, no problem. So, formulation part you may go for patent, you may go for trade secret, although definitely all have to need all the things that characteristics of patents need to be meet to get for getting it patentable, getting it protected by means of patent, and similarly trade secret aspects also you have to meet for protect it in the form of a trade secret. Now, say with reference to a individual, you want to be an entrepreneur, I will consider that aspects, and second aspect I will consider as a business entity, and third aspect I will consider with reference to an individual who is not an holder of patent and trade secret, means societal aspects with reference to both the forms of protection. Okay. So, now the patents, the formulation can be patented. Okay. So, process, the criteria required for that let us say having novel, having inventive step and have capacity to applicable and capable of industrial application. Okay. So, definitely you are thinking about that formula have all the attributes. So, you are going to file a patent. Then what will happen? If you file a patent after 18th month it will be disclosed to the public. So, it will be disclosed to the public. So, this is not remaining as a secret per se. Okay. So, now if you go to for a patent, so you have to meet some procedural aspects. 18 month, after 18 month it will be published. Okay. So, now it will go for examination, then ultimately opposition, all sorts of things, then it will be granted. If granted, then we will get a patent. Okay. Now, let us say consider a situation during examination and your in examination or opposition your patent get, say you paid examination and opposition, that somehow let us say examination after hearing the patent office rejected the patent, rejected the invention, or after if or during opposition it may ultimately decided in favor of opponent, then the formula you do not have, whether formula you have any rights per se, no. Why? Because it is already disclosed to the public. So, secret attribute of the formula has lost. During examination and subsequent opposition or examination, during examination it has not qualified the criteria of patentability, so patent office rejected, or during opposition the opponent found that it is not meeting the patentability criteria or rejected, or even after grant subsequently it may revoked, Okay. Subsequently also it may revoked. So, see you have a formula that you are thinking about a potential IP, now you are going by a patent route. The where is the risk associated to go by patent route? If that thing is not get patent, your formula is not having capability or capacity to be awarded for patent or to be granted for patent, then you are not getting patent and you are not getting a trade secret out of that. Okay. So, I will see that in this case you may lose a potential IP. Okay. So, but benefit for the others means let us say third person who is let us say third person here, or he is a part of the society, societies, he part of the society, society benefit. So, some say some formula is now become public good, formula of that cold drinks now become public good, advantage that anybody can make that cold drinks using that formula, non-rival, non-excludable, okay, because now it is not in the form of any IP except let us say if you are keeping some elements within the purview of know-how and other, that is the different elements, but I am considering the formula as such. Okay. So, there is no right associated. So, risk, what is the risk in respect of this patent? A risk with reference to the patents. So, if it is not granted, means risk, let us say risk with reference to a risk for patent, this part we are telling risk, later part we will consider. First let us consider the patent part, risk with the patents if not granted, if opposed and opposition decided against you, opposition decided against you, or even granted if revoked. Okay, if revoked. So, these are the risk associated with that formula to get it patented. So, now say if I consider again come back to the trade secret. Now, you are thinking that okay, I will protect my formula in the purview of trade secret. Look, you protect your formula by means of trade secret, means you are keeping the information as a secret information, you are taking a reasonable step to keep it secret definitely to make it so to definitely having a commercial value. Okay. So, now risk means what are the risk with the that formula to keep within the purview of trade secret? A risk is let us somebody discover that formula, independently discover that formula, is independently discovered independently. What do you mean independently discovered? Means without knowing about the formula, he has come out with the same formula whatever you are keeping as a trade secret. Then whether you will able to enforce your right against that discoverer of that formula, per se no. Okay. So, you will not get any, will not able to enforce your right against the person who will independently discovered, subsequently discovered by or developed by reverse engineering. What he have done? Somebody have let us say purchased that cold drinks, he has now tried to find out the formula of that and somehow achieve that formula, whatever formula you are trying to keep it as a trade secret. Okay. So, whether you will able to enforce your right against that person? No. So, independent discovery, reverse engineering, by virtue of that you may lose your potential intellectual property. Again, there is a chances of say inadvertent disclosure, theft, or inadvertent disclosure, inadvertent disclosure. Okay, that I am not writing. Theft, inadvertent disclosure. These are the different type of risk associated with reference to the trade secret. Okay. So, formula by virtue of trade secret, what are the risks associated with the entrepreneur or with the organization, means discovered independently, developed by reverse engineering. Okay. And so, and say inadvertent disclosure. So, then again there is a problem I last class also told regarding enforceability. Okay. So, that way the problem with the respect of trade secret or risk associated with the trade secret are all these. Okay. So, now we just told about the risk with reference to the patent, risk with reference to the trade secret. Now, let us tell, because you have to make a decision, how can you make a prudent decision where the risk is minimum, where the risk is maximum, how will you decide about that. Now, if you consider here based on the risk part and considering your formula part, how will you decide which will be the better form of protection. You know now why I am telling the better form of protection, and where let us say first consider better form of protection, because patent is protected for 20 years and trade secret will be protected as long we will able to keep it as a secret, means they are not publicly known, not disclosed publicly. So, so that is maybe one day, it may be 100 years also. So, definitely as an individual aspect, you will get more exclusive rights or more right in when in a you protect it in the form of a trade secret compared to the patent. So, now how will you make a decision, an individual and organization, how will you make a decision that you will go for trade secret or for a patent, means how will you decide with reference to risk here. So, definitely you have to judge your formula or formulation or product attributes. Now, you have to decide whether it is easy to reverse engineer or not, whether it is easy to develop independently or not. If it is easy to reverse engineer, then which will be the appropriate route? Obviously, patent, if it qualify the characteristic of the patent. So, obvious route will be patent, but if it is very difficult to reverse engineer, is not possible to at all reverse engineer, then I think you should go for trade secret. Okay. So, that way you understood that how you are making a decision, they are ultimately decision that who will tell this part, the engineers, technologists or R&D people, they will thought about the attributes of that product including composition, process of synthesis and others, whether it is easy to reverse engineer, because product will be available in the market. Okay. So, if product is available in the market, whether people can go for reverse engineering or not, that is the other aspects. So, they will definitely go for it, because competitor will always try to just like said try to somehow develop something which will be better than you or at least your product. So, that way that if it is not easy to reverse engineering, then you should go for trade secret. Now, you understood the risk and benefit with reference to risk and benefit. Risk part already told. Benefit part means in patent, let us say benefit part, let us little bit discussed versus trade secret. Okay. Benefit means you are even if you disclose the things in a public, you have exclusive right for 20 years, assured right for 20 years. So, if you are thinking about again a decision making, if you are thinking about that your product or process, you can use it on license basis and on cross license basis, and that will give you a better market power, a competitive edge with reference to the market in a market, then I thought also you can think about going for patent. Even 20 years period will be enough. Okay. So, 20 years exclusive right, assured right if you got the patents. Here always you have to be under toe to keep it secret. Always under toe you have to keep, means sometimes people say that cost associated higher, but there is no processing cost. Understood? Cost for protection sometimes they told higher, but there is no as such. You can consider the econometric analysis regarding that, where the cost is maximum. Okay. And advantage here also you understand is no processing thing, no processing, no registration, no processing, no processing. So, we will get the right, just like here advantage, disadvantage sometimes people tell, at least you may require some time to get the patents, that what rights you have during that period, although you have a rights from the date of patents, means day of the filing patents, but till that time of grant, whether you will really able to enforce it by law, the question remains. But here you have the rights from the day 1, because there is no registration, there is no processing. Okay. So, the advantage with reference to the creation of right, creation of right, CR, creation of right, advantage, trade secret, enforcement. So, creation of right, trade secret, transaction of right, patent advantage, because cross licensing and others. Here always you have to fear of disclosure, independent developed, reverse engineering developed in respect of trade secret, transaction of right part, TR let us say. Okay. Advantage. Okay. So, enforcement I will put enforcement of right, advantage this side. Okay. This way patent part is advantageous this side. Okay. So, that way you are getting that pros and cons of that formula to get to protect in the purview of a particular forms of IP. Now, you may ask me whether I will go for dual protection. I will suggest you may ultimately avail that, because let us say product you patent it not say try to avoid disclosure about the exact product composition or formula or attributes somehow, then you can get a patent and the exact formulation or the process parameter and others you are keeping in the purview of trade secret. No problem, you are keeping in the purview of trade secret. Okay. So, that way you are getting a dual protection, I will say, that patents, and even after expiry of the patents, you are have a trade secret with some components of your product. Okay. So, that is the things sometimes we call know-how. Know-how part you may embed in the form of a trade secret. Okay, that part you may consider, but say you have to decide, think about the know-how is, it will be possible to independently develop or say discover, then I think say immediately when the patent say will be disclosed. So, automatically people may get the know-how out of that, then you are losing the rights over the trade secret. So, you may consider that aspect. I will sometime I can try, let us say research aspect, let us say after till 18 months your know-how is somehow 18 months or beyond something till people are not able to try that, remains as a trade secret. Okay. So, that way you may consider also. Okay. So, that way, that how you are making a decision with reference to your product or formula, that part. I will provide some say hypothetical cases, or this is real case, but I am converting in the hypothetical one. Let us say some generic some pharmaceutical company manufacturing some drug. Okay. So, they are protecting some attributes of that drug by virtue of patents, and even after patent period is expired, no generic company is able to produce that drug. Got the thing? So, they got they protected something in the purview of patent, but they have not disclosed maybe the exact formula and others in the patent specification. And so see that the process part nobody is able to repeat and nobody is able to produce that generic drug. So, you understood, even after the patent period is over, they are trying to protect, they are getting the trade secret over that. Similar type of situation, let us say somebody has filed a patent with reference to the e-commerce, let us say Amazon one click patent, e-commerce related invention. So, now they have tried to protect it by virtue of patent, but patent office denied. So, what is happening? So, if they try to keep it within the purview of trade secret, then they will be beneficial, but they have tried to make it within the purview of patent. So, they lost a potential IP. So, when you are thinking about to protect something in the purview of patent or trade secret, then which thing will make will you help to make a decision? First thing, whether invention is that on the attribute, say that is in patentable invention, is patentable or not, patentable or not. If it is not patentable, try for a trade secret. If it is patentable, then just like that drug company thought about, okay, let us keep whether it is feasible or not, try make an attempt. Okay, that will be more prudent, because you are trying to somehow getting a dual protection kinds of situation, but difficult. Okay. So, then third attributes, just like say if it is if you are thinking about there is a chance, less chances of get it patent, go for a trade secret. Okay. So, that way you are deciding that invention and its attributes, how you are analyzing whether it is patentable or not, whether there is a chances of getting patent or not, just like say considering software per se is not patentable in India. Okay. So, now you are telling that you have developed a source code, and that source code per se is difficult to reverse engineer or independently developed. I will suggest go for TS, trade secret. Okay. So, something similarly, let us say you have you have what do you, let us say created a medical method of treatment, and in the, just like a method of treatment, say you only having that knowledge or information of that method of treatment in India. Then you keep it a trade secret, you know that particular say in somebody told that, and Hyderabad and on the particular region, a particular community only knows how to treat asthma. Similarly, in India, a lot of these kinds of things are available in the form of a traditional knowledge in a particular community or within that. So, whether that thing is coming within the purview of trade secret of that community, that is definitely we may consider that way. Okay. So, that way you have to decide that what is the characteristics of your invention, then you make a decision whether you will go for patent and trade secret. And lastly I can tell with reference to the societal part, just like a third person I have mentioned here, the society who is looking for that, for him which will be beneficial at patent part, because after 20 years it will be considered as a public good. So, they can anybody can manufacture that product, that like a generic drug. Okay. So, then there may be a chances of let us say chances of price decrease in respect of escalations. Just like you consider after patent period is over, when the generic drug is available in the market. So, maybe the cost is lower, because lots of companies coming to manufacture their generic drug, and they are selling they are using their brand at different prices. Okay. So, then that way that it may lead to the decrease in the price. So, it will be beneficial for Mr. this X society. So, patent is better always for society, but let that company who is after patents also given that nobody is able to do reverse engineering. So, definitely that cost for that they will delta will increase. So, that is why the pros and cons of patents and trade secret, that part only we discussed. So, this is also a legal and managerial part. So, for that reason this is also important for your engineers and technologists, because you will work in an organization, and this knowledge will help you to help the organization to make a decision with reference to patent and trade secret. Okay. I am closing it here. Okay.